Afternoon. Welcome to WG University Weber Gallagher's series of educational programs. This is our employment webinar series, and I'm Alexander Ross, and I'm presenting today with Julie Kinkoff of our Philadelphia office. Today's presentation is Big Changes in New Jersey Law That All Employers Need to Know. If you'd like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Let's get started.
Okay, so here's our agenda for today. There we go. We're going to talk a little bit about the New Jersey Law Against Discrimination, the LAD, give you a quick overview, and then talk about the new amendments to the Act, the Diane B. Allen Equal Pay Act. And Alex is going to tell us about the New Jersey Paid Sick Time Law. So first of all, the LAD. Okay, so the Law Against Discrimination is the New Jersey state statute that applies to employers of all sizes. It prohibits discrimination and retaliation. It requires reasonable accommodations. It is much broader than the federal statutes. There are many differences between the LAD and the federal statutes that employers in New Jersey need to be aware of. One of the most notable ones is that you can go straight to court. You don't have to go to the EEOC, and you don't have to go to any state agency before you go to court. The LAD is also much broader than federal statutes. These are all of the protected classes. Now, we don't expect, I'm not going to read all of those, but the point is that there are quite a bit of them.
A lot.
Yes, and the other thing that you need to know about for New Jersey is disability is much broader in New Jersey than it is in the under the ADA. Okay, so now this is our new statute, or our new amendments to the LAD in New Jersey. It is the Diane B. Allen Equal Pay Act, which was named after a legislator in New Jersey. It is much broader than the Federal Equal Pay Act. It is not limited to gender. That's important to keep in mind. It applies to all of the protected classes that were listed on the previous slide. It has an extended statute of limitations. Every paycheck is a new violation, and unlike the Lilly Ledbetter Act, which is the federal statute, the statute of limitations is up to 6 years. The Allen law also has enhanced remedies that we're going to talk about, and also broad anti-retaliation provisions. Okay, so as a general matter, what the law does is it prohibits employers from paying a member of a protected class less than a member of who's not a member of the protected class for substantially similar work. Substantially similar work is going to be determined by a composite of skill, effort, and responsibility. The test for substantially similar work that's in the New Jersey statute is similar to the test that they use in California. So that might be a basis that the courts might use as a comparison moving forward. There are a handful of legally permissible reasons for different pay rates. These include seniority, merit systems, or that kind of catch-all, which in the New Jersey statute is legitimate bona fide factors, other than sex or other protected factors. The catch-all phrase, the last one, only applies if the differential is based on one or more legitimate bona fide factor other than protected class. So something like training, education, experience, or quality or quantity of production. Those training, education, experience, those terms are also used in the New York Equal Pay Act, and so that might be a basis for the courts to look at in applying the New Jersey statute. The factors cannot be based on the differential protected status, protected class, and they can't perpetuate the unequal pay. All of the factors have to be applied reasonably, and this is pretty important. The factors have to account for the entire wage differential. It can't be just part of it, but it has to account for the entire wage differential. The factors have to be job related with respect to the position and based on legitimate business necessity where no alternative business practice would serve the same purpose. So
sounds like there's a lot of space here for ambiguity, isn't it?
Yes, there is, and I'm sure that there's going to be a lot for the courts to interpret here. Now, another thing with the pay differentials is that you can't justify a pay differential based on geography. So if, cost of living can't be a factor. So people who live in Bergen or Hudson County have to be paid the same as people who live in Salem County. This is also similar to the California law. And if you're going, when you go to try and comply with this statute, you can't lower anybody's pay. Everybody has to go up. So nobody gets their pay reduced. People who are not being paid an equal wage get a higher wage. Okay, so that's the pay differential part. The other thing in the statute are these retaliation provisions. And these retaliation provisions are pretty broad. You cannot retaliate against employees for requesting information, disclosing compensation information, for seeking legal advice, or for sharing information with a governmental entity or legal counsel. The provisions there for legal counsel are different than what was in the LAD before. So those are something that you need to be aware of. All right, moving right along here. The statute has enhanced damages. So you have the usual damages that you get under the LAD for, for violations of the LAD, which includes compensatory damages, punitive damages, attorney's fees, all of that. But in addition to that, you can get enhanced damages for violations of the equal pay portion of the statute. And that includes trouble damages. So 3 times the amount of pay differential, 3 times the damages for retaliation. And as we said in the beginning, each paycheck is a new violation. So you have, it continues, the violations continue to accrue, and you can go back 6 years. The statute of limitations under the statute, under this provisions of the statute, is 6 years for the equal pay portions. Employers cannot ask employees to waive any rights under the Act, which means you also can't ask employees to agree to a shorter time period than the 6-year statute. Okay, so those are the basics of what the law is, the new equal pay law in New Jersey. So what do you need to know? What do you need to do as employers? First of all, the law is going to take effect July 1st, so we have not very much time to prepare. It is going to be important that employers audit their pay practices and determine which employees are being paid the same for substantially similar work and which are not being, which are not currently being paid the same for substantially similar work. It is important to formulate strategies for compliance on this. You may want to consider hiring counsel that is experienced in equal pay matters and experienced in employment law and discrimination matters. And one of the reasons why you want to do that, in addition to the experience, is some of the communications may be protected by the attorney-client privilege or other privileges. So that's the super quick overview of the New Jersey Equal Pay Act, and I am going to turn it over to Alex here, who's going to tell us about the new sick leave, paid sick leave law.
Yes, thank you, Julie. Yeah, as it says on the title page, the New Jersey new paid sick leave law is not just for sick people, but people who have conditions beyond mere illness. All right. The way it works is that you are, as an employee, you accrue 1 hour for every 30 hours worked, up to 40 hours per year. And you can carry forward unused unpaid sick leave or paid sick leave for up to 40 hours for the next year. It applies to all New Jersey employers, and it goes into effect in 6 months from now. Not July 1st, but October 30th is the day that this will go into effect. So this involves all employers, even a small pizza shop or Johnson & Johnson in New Brunswick, any large company like that, this would apply to. Now, an interesting part of this statute is what can this paid sick leave be used for? It's not just for sickness. One of the categories, the first category, of course, is preventive care or treatment for physical or mental illness of an employee, but then it also includes a family member, and we're going to get into what is the definition of a family member pretty soon. It also would allow paid sick leave for absences due to domestic violence or sexual violence. Also, if a school or workplace is closed by a public health emergency. Public health emergency is kind of broadly defined too, and it's questionable whether that would include, for example, a snow day. Is that a health emergency or just a safety emergency? A flood, who knows? A hurricane could be a public health emergency because we don't want people to be traveling during hurricanes. It could affect your health, and so that would probably be affected by that. Also, interestingly, you get paid sick leave for a school conference for a child, which probably indicates the power of the teachers union in New Jersey. That means if you're a required or recommended conference for a child or some event sponsored by the school, you're entitled to paid sick leave for that. All right, now what is the family member? That's a very broad definition under this statute. It includes the typical nuclear family, like a husband and wife and the children, but it also includes grandparents and the spouses of grandparents, brothers and sisters-in-law. Then it has a catch-all phrase which includes any other individual related by blood or whose close association with the employees is the equivalent to a family relationship. So if you think about that last one, Julie, it could include a Dutch uncle or anybody that you feel close to that has some kind of illness that requires you to be to take care of that person or to feel like you have to take care of that person.
So when in doubt, maybe you should consider them to be a family member if you're an employer?
That's right. So if someone comes to you and says, my friend growing up from elementary school lives in Colorado and was suddenly diagnosed with an illness, I have to go out to Colorado and hold his hand for several days, that would be included under this statute, under one interpretation of this statute. So it's a very broad definition of what includes a family member. All right, now, how does an employee use sick leave under this statute? Well, if there's a foreseeable sick leave, for example, you know that you have a conference with your child's teacher a week from now, you're supposed to give advance notice of that up to 7 days under the statute. Or if you're going to have some kind of surgery that is a scheduled surgery, for example, a hernia operation or something that you can schedule, you have to give your employer notice of that. If it's not foreseeable, if you have a sudden illness or a traumatic injury of some kind, then you have to give notice as soon as practicable. It's not a blank check. You can't take a paid sick leave because you want to go and play golf one day or because you have something else you'd like to do. It has to be something under those 4 categories that I just mentioned. Also, the employer can ask for reasonable documentation, but only under certain circumstances. If the employee is out for 3 or more consecutive days, or if the employer can actually prohibit taking sick leave on certain dates. For example, a retail department store may not want its employees to be off during the Christmas sales season, which is very busy. Or a pizza shop operator may not want its employees to be off during the 4th of July weekend or some other holiday weekend when they would be very busy. So if for some reason an employee wants to be off on those days or requests leave off, you can ask for reasonable documentation for that. All right, so you get up to 40 hours, but if you want to cash out, you must give 10 days notice at the end of the year, but that's only for 50%. You can carry up to 40 hours over for the next year, but not more than 40 hours. That was something done at the last minute during negotiations. The Chamber of Commerce, at one point, the statute allowed up to 72 hours, I believe, but it was negotiated down to 40 hours. That's the max.
So does that mean that an employee can never have more than 40 hours of sick leave in their bank?
That's correct, unless, of course, the employer already provides that. If for some reason you have a very generous employer, and that's one of the things we'll talk about in a moment, if the employer already provides vacation time or other paid time off, sick leave, personal days, more than 40 hours, you can't reduce it under this statute. All right, and if an employee leaves or is terminated, they do not get their sick leave unless the employer already had a policy allowing them to keep their sick leave.
So that's going to depend on what the policy is existing at the time.
That's correct. All right, like the Diane Allen equal pay law, you cannot retaliate if someone takes sick leave. What is retaliation? Retaliation is any adverse employment action or a threat of an adverse employment action. So you didn't even have to take it. If you threaten that you might do something to an employee who takes sick leave, that constitutes a violation or a retaliation. Also, there's a rebuttable presumption if an adverse action is taken within 90 days of a protected activity. So, for example, if you take sick leave and then within 90 days after that, your employer starts complaining, you're always absent or something like that, that would be a type of retaliation, a threat of retaliation.
That's an interesting provision in this law. I'm not familiar with the rebuttable presumption in other laws, because almost all of the laws in New Jersey, all the employment laws, include anti-retaliation. Do you think that that might be used by the courts, you know, in maybe an LAD type case or another type case to say, when they passed the sick leave law, the legislature said that there would be a rebuttable presumption within 90 days. We don't have one here in this statute we're talking about, but you know, maybe I'm going to apply one anyway.
It could very easily be extrapolated to other statutes. You know, this is one of the big factors we see in litigation, is that someone is for one reason or another, is punished or disciplined at work, and then they think, well, I took sick leave within 90 days, so you're doing that in retaliation for me taking the sick leave. And it would very easy for a court to say, well, you know, there's this 90-day safe harbor that you have after you take sick leave, so can you not touch an employee? What if an employee does something that merits termination within 90 days? That could result in litigation.
Yeah.
All right, there's a 5-year record-keeping requirement for all sick leave.
So what if as an employer, I already have a sick leave policy? What does this mean? What does the new statute mean for me?
Well, the good news is employers don't have to add another 40 hours of paid sick leave or paid time off for their employees. If you already have paid time off consisting of vacation time, sick leave, or personal days that equal 40 or more hours, then you're safe. You're in a safe harbor. You don't have to change anything. You cannot reduce the amount of time you already give employees. For example, by seniority, a lot of employers allow extra time off if you have 10 years of work, 15 years of work, and so forth. So you cannot use this statute to reduce it. But as long as you already have 40 hours of paid time off during the course of a calendar year, you're okay. So what this statute really does is set a floor, a minimum floor throughout the state of New Jersey for a minimum of 40 hours of paid leave for all employees.
So, and it also sets a floor as to who's going to be considered a family member, right?
That's
and what
correct.
sort of areas can be used, this type of leave can be used for. So our clients are going to need to look at the policies they already have, right?
That's right. That's right. Yeah, this really broadens the law with regard to paid sick leave. Not so much in terms of the hours, because many employers already have paid time off that is close to or almost 40 hours, but it's really going to be how this is broadened so that it's not just the employee who gets paid time off, but anybody the employee knows that is close to has a problem, the employee can ask for time off for that.
Right. And so would you recommend that companies look at the current leave policies that they have and make sure that the definitions within those policies comply with the law?
Absolutely. As I said, this takes effect October 30th, so there's ample time to look at it, but you want to make sure that you have to be in compliance with the statute. So up to 40 hours for any family member being very broadly defined.
Okay, and what sort of remedies? I know you said that there were the usual wage and hours remedies. Can they also get attorney's fees for this one?
There is attorney's fees and costs. Once again, just like you mentioned, you don't have to go through administrative hearings. You don't have to go through the Division of Civil Rights in New Jersey. You can go right into court, and liquidated damages would be double what the time is that you've lost, plus the same damages as are in wage and hour, which includes a misdemeanor, and it could be a disorderly person's offense if it's viewed to be an intentional violation.
All right, well, this sounds like something that we need to definitely make sure we keep an eye on. So thank you for attending our webinar, Big Changes in New Jersey Law That All Employers Need to Know. You can learn more about this program and all of the other Weber Gallagher events at www.wglaw.com/WG-University. Have a great day. Thanks.
Thank you.